Hello, everyone, and welcome back to 2A News with Craig DeLuz. I am your host, Craig DeLuz. This is a place where we're going to talk about firearms policy, politics, culture, media, you name it. We're going to talk about all things gun, all the gun time. So thank you so much for tuning in. Thank you so much for encouraging your friends to tune in and subscribe. By the way, make sure you like, share, and subscribe. Also, want to let you know if you're going to be at SHOT Show. SHOT Show is a phenomenal event. It's the Shooting Hunting Outdoor Trade Show. It takes place usually that third week in January every year. It's put on by the National Shooting Sports Foundation. Phenomenal event, huge event, and we're going to be doing a welcome party. It's going to be done. It's going to be that Monday evening. That would be Monday, January 19th. It's going to be from 7 to 10 p.m. at the Hofbrauer House. And we've got a number of different folks who are going to be hosting and sponsoring, but primarily it's being put on by the folks over at Arms Room Radio, by 2A News, and The Rundown. And then, as you can see, there's a number of different sponsors there that you will recognize. So if you're in town or you can be in town, this is a free event. Once again, would encourage you to come on out. There will be hors d'oeuvres. There will be plenty of beer and plenty of swag to be had. So once again, if you can make it, please do. We would love to have you join us. All right, let's get into today's topic, and that has to do with open carry and a recent decision by the courts here by the Ninth Circuit Court of Appeals dealing with the issue of open carry in the state of California. As is being reported here by The Hill, an appeals court strikes down California's open carry ban for most of the state. Now, what does that mean? Well, that means because open carry was banned in the most populous counties in the state of California, meaning if you had a population of over 200,000, your county, you were not allowed to open carry. And if it was a county under 200,000, you could apply for a permit, meaning you didn't just have a constitutional right, you had to get permission in order to be able to carry. Let me read a little bit of the story that they have over here at The Hill. It says, a federal appeals court ruled Friday that California's open carry ban in most parts of the state infringes on the constitutional right to keep and bear arms. The Ninth Circuit Court of Appeals panel voted 2-1 that the ban runs afoul of the Supreme Court's expanded Second Amended test, which requires gun control measures to be consistent with the nation's historical tradition of firearm regulation. U.S. Circuit Judge Lance Van Dyke, writing for the majority, said it was a straightforward case since open carry wasn't banned at the nation's founding. Quote, quite the opposite. In antebellum America, it was clear that open carry was widely seen as entitled to special constitutional protection, Van Dyke wrote. California banned open carry in counties where the population exceeds 200,000 people, which covers where the vast majority of Californians live. Mark Baird originally sued over the law in 2019. His case has zigzagged through the courts for years and was bolstered by the Supreme Court's expansion of Second Amendment rights. Now, to further discuss this decision, we have joining us Mr. Chuck Michel. Now, Chuck Michel is with the California Rifle and Pistol Association. So with that, I'd like to once again welcome to the program, Chuck Michel. Chuck, welcome to the program.
Thank you for having me. Always a pleasure to be here.
Excellent. So help us to understand a little bit about what did this three-judge panel in the Ninth Circuit, what exactly did they decide, or what was the decision when it comes to open carry here in the state of California?
Well, good question. You have to consider this ruling in the Baird case in the context of all the other cases that are being litigated in front of the Ninth Circuit, and for that matter, in other circuits across the country, because there's a battle going on about what the proper way to apply the methodology that was laid down by the Supreme Court in the Bruin case is. That methodology is supposed to be fairly straightforward, and it will mean that many gun control laws will not survive a Second Amendment challenge if it's done faithfully and the way the Supreme Court instructed courts to do it. The problem is many courts, and especially some of the judges on the Ninth Circuit, have been twisting the Bruin to a way that allows them to uphold a lot of gun control laws that really should be deemed to be unconstitutional. And so the Bruin test says you decide whether or not, first of all, whether or not it's whatever the conduct or hardware or whatever that's being regulated by the law that's being challenged is covered by the language of the Second Amendment, the right to keep and bear arms. Almost everything is, whether it's a piece of hardware, an AR-15, a magazine, a suppressor, a shoulder stock, whatever hardware, or a class of people that are being prohibited, or certain places that are being prohibited. The Second Amendment doesn't just apply you. It doesn't just allow you to buy one gun. You have to be able to go to the range, and it's not just about self-defense either. By the way, it's about hunting, sport shooting, any other lawful uh, reason to own a firearm. Self-defense is at the core of that, but the Supreme Court never said that's the only reason that a law uh, is that the Second Amendment exists. Anyway, so then the second step is, and the Supreme Court went back to the originalism test rather than the living Constitution, where you get all kinds of weird interpretations. They go back to originalism, which is, what do the founding fathers mean when they wrote this Constitution and the Second Amendment? If there's some historical law that is analogous to the modern day law, then that's an indication that the founding fathers would have tolerated the modern day law. They didn't mean to ban the conduct that's being regulated, or they didn't mean to stop the government from regulating the conduct that's being regulated if they allowed it to be regulated back in 1791. So there's a huge battle about what is covered by the text of the Second Amendment, and that's our Duncan case and the magazine capacity lawsuit, and the Rhodey case, with the ammo purchases, and then is it covered is the first part, and then is there a historical law that indicates this modern law would be tolerated by the founding fathers? Well, so getting back to Baird, you have a huge fight going on within the Ninth Circuit between certain factions of the judges there, led by, on the pro Second Amendment side, by Judge Van Dyke, who was the author of the Baird decision, where he faithfully applied the Bruin analysis. He said, of course, carrying a firearm, whether open or concealed, is covered by the Second Amendment. That was the Bruin test, even though the Bruin test was concealed carry. And then, so it's covered by the Second Amendment. And then, is there a historical law that would indicate the founding fathers would allow you to ban open carry? Well, there isn't any. In fact, at the time of the founders, and for many years after, the primary way people carried was openly. So there's no law that from history that would indicate that the modern day open carry ban would be constitutionally permissible. So he just faithfully applied that Bruin language and concluded that the ban on open carry throughout the state, the law was that if in a county of under 200,000, you could apply for an open or a concealed carry license, but the other counties, you had to do just a concealed. You had to apply for a concealed carry license. So what the court 2-1, actually it's 2.5-1 really, because even the dissent was on board with a lot of it, said it's the open carry ban is unconstitutional. Now there's going to be some big questions coming out of that, though.
Okay, so it's interesting that you point that out. A lot of people don't even realize you could actually carry a loaded firearm in public, with the exception of sensitive places, until the 1960s and the Mulford Act. And you could actually carry an unloaded firearm up until 2012 in the
Right.
state of California. So yeah, so this whole idea that this is crazy and that it brought about the Wild West is a gun grabbing misnomer or misrepresentation of what the law's been for most of the history, even here in California.
Yeah, it's another scare tactic. It was the 20s when they started the whole CCW licensing process. You had the Sullivan Act going on in New York, and that was basically banning concealed carry or loaded carry completely. And rather than do that, they came up with the licensing system for concealed and unconcealed, in some circumstances, licenses. But they set up the good cause standard so that could be interpreted and misinterpreted and subjectively misused by issuing agencies to say, unless you had, a signed threat from a stalker, that said, "I'm going to kill you," didn't have good cause to get a license. That evolved when the CRPA did the Peruta case, even though we lost eventually uh, en banc, which started the whole en banc Ninth Circuit's en banc shenanigans, where you win at the three-judge panel and they take it up to the en banc panel and then you lose. Um, but the Peruta decision persuaded. It wasn't mandatory, but it persuaded a lot of sheriffs to start issuing. So you started getting more of these CCW permits being issued. But the interesting thing and the telling thing that really reveals what the games the state is playing, since the 20s, none of these places that the state is now declaring to be sensitive were deemed to be sensitive. If you had a CCW or an open carry license, you could carry there. There's never been any issues with that for 100 years. But now they're declaring that those places are sensitive, and so your license, whether it's a concealed or open carry license, is not valid in those areas, which is just another way to try and dissuade people from going after a license, whether concealed or open, to carry, because it takes so long, it costs so much, and it's only good in certain limited places. So, but that's part of the game. That's what we call the blue resistance. And this is part of the CRPA's reckoning project, the CCW reckoning project, where we're going jurisdiction by jurisdiction, hammering those jurisdictions to issue quickly and cheaply, so that the right to get a license is available to everybody. But the open carry side of this has been, it's a sort of a section of the Second Amendment activist community. And the reason that they banned open carry was because they were doing open carry protests, and that's their right, God bless them. But they were showing why the California's laws should be scrutinized. This was before Bruin, and so it's always in response to something like the Mulford Act or the ban on loaded carry was in response to the Black Panthers marching on Sacramento. Even Ronald Reagan signed that law. So it's those things happen, and then the legislature responds by trying to clamp down on it, even if it's unconstitutional the way they do it.
So real quick, what is the immediate impact for gun owners in California when it comes to is there any impact on concealed carry, and is there any impact on the ability to open carry as of right
Not
now?
yet. Not yet, because the mandate has to issue. It's just an opinion right now. It's not final. And the state will definitely appeal this to the en banc panel, like they do in every case they lose, and they're losing more and more at the three-judge panel, especially when you get a panel with Judge Van Dyke and some of the other Trump appointees on there that recognize that actually do what Bruin told the lower courts to do. So we'll see what happens en banc, but for now, the ruling is not final. The more important to me, the more important impact that this decision has is that it's another case, a three-judge panel case, where the court faithfully applied Bruin. That's the larger battle that's going on across the country. That's one of the questions that should be answered, hopefully, in the Wolford case that's in front of the Supreme Court, or the Harmani case on marijuana use and prohibiting people from owning guns if they use marijuana, that's in front of the Supreme Court. If the Supreme Court takes those cases, and maybe some others, Duncan is still up there on the magazine ban, and I think there's 30 other cases that are asking, Second Amendment cases, that are asking the Supreme Court to review the lower court's decision. Ultimately, the Supreme Court really needs to make clear, it needs to kind of slap the lower courts around a little bit and tell them, stop misapplying, mischaracterizing what we said in Bruin, and get real and do what we say, because we are the Supreme Court. What we say goes.
Well, I thought one of the things I've always said was interesting, in particular when it comes to sensitive places. Justice Thomas made it a point to talk about, look, you can't just make every place a sensitive place. And it was like he was literally foretelling what he knew they were going to do, and yet they've been doing it anyway.
And he said a licensing system is okay as long as it's not abused by taking too long or costing too much, and that's exactly what they're doing. So yeah, it's very frustrating. And I know, believe me, I know how frustrating it is for people who watch too, and the people who donate to the CRPA, support CRPA, other groups. I mean, it takes a long time, but we're on the cusp of I think, a breakthrough. We sat for 12 years after Heller before we got Bruin, and now we've sat for almost 3.5 since Bruin came down. Uh, we're we're going to get another breakthrough ruling from the Supreme Court. They know the majority of the justices are well aware of how they're being disrespected by some of the lower courts, and they are going to set things right.
Well, I'm very
And
much
that's
looking.
and that's when a lot of things can start to tumble.
I'm very, very, very much looking forward to that because it's very frustrating to see that the decision's been made and recognize that literally there are people in the judiciary who've decided I'm going to, in the best of my ability, defy and ignore exactly what it is that the Supreme Court has said.
Exactly. This was when Judge Reinhardt, who used to sit on the Ninth Circuit, was asked, "How can you keep issuing these rulings?" He was a notoriously liberal judge. How can you keep issuing these rulings that are contrary to Supreme Court precedent? He said, "Well, they can't catch them all." I mean, it's not
That
exactly the
is
attitude you'd expect from a judge who's sworn to uphold the Constitution, but in his mind, I guess that's what he thought he was doing. They think the Supreme Court got it wrong.
okay. Well, a lot of our audience, at least in California, knows about CRPA. Why don't you do me a favor and just tell the rest of our audience, the national audience, a little bit about CRPA, about the work that you do and how they can be in contact, follow that work, and support your organization.
Well, thank you for the opportunity. CRPA has been around for 150 years. It's one of the oldest civil rights organizations in the country, focusing on Second Amendment rights. But also, it's a full stop shop. It's we do all the programs, the juniors programs, shooting development, competition, matches, hunting and conservation. I mean, we have so many programs that beyond the Second Amendment litigation program, which is one of our biggest right now. But you have to actually get people into the shooting sports if you want to have people appreciate how much fun and you know enjoyable being in the shooting sports can be. Not only and also be aware of the politics of this and how distorted the Sacramento politicians are when it comes to this issue. So we do training. Basically, just like I said, full stop shop. We do it all. Litigation program is huge. We have about a dozen cases going on across the country right now. We've actually mostly in California. We do amicus briefs across the country. If you count amicus briefs, there's probably 20 more. And then we're very involved and formed the Hunting and Conservation Coalition, which is all the hunting groups coming together to combine their lobbying influence in Sacramento. And we have a full-time lobbyist in Sacramento who's doing a great job. The deck is stacked up there, but we're still stopping a lot of bad laws from passing in Sacramento. So we do it all, and if anybody can, by the way, even if you're not in California, you should think about joining CRPA at crpa.org, because the stuff that starts here, it's not like it accidentally drifts across the country on some prevailing wind. The gun ban lobby spends millions of dollars. I call California the moldy petri dish of the laboratory for gun control laws. They spend millions of dollars developing these laws here and in Illinois and in New York, the other battleground states, and then pushing it to any state where they can get a foothold. Even some of the red states, certainly the purple states, they will come. So help us, stop this stuff before it makes its way out of the poison Frankenstein laboratory in California and comes to a state near you or a city near you. But CRPA.org and the lawsuits that we're doing are also setting national precedents, not just California specific. There's hardware cases, there's the banned guns, banned hardware, banned people, banned places. Those are the three main types of laws that impact Second Amendment rights. And if you get a win here, now that it's a national game, If you get a win in California, it applies nationally. If we get a win someplace else, it applies in California. So it's a national game, and CRPA is playing it. We're right out in front.
I could not have said it any better myself. The being in California, it's like every bad idea that I see happening nationally was proposed at one time, and in some cases is law here in the state of California. So, fighting here in California, you guys know all of the arguments that are going to be presented already. You know all the lies that are going to be told. You know all the arms that are going to be twisted. So having someone who knows the playbook is quite helpful. So, and by the way, if you can support it before it becomes a national thing, kill it in the crib, for lack of a
Yeah,
better term. I think that's a phenomenal idea. Chuck, thank you so much for coming on the program. Hope to have you on again real soon.
always a pleasure, brother. Anytime.
All right, well, that's going to be it for this episode of 2A News with Craig DeLuz. We very much appreciate you tuning in. We appreciate you liking and sharing the program and encouraging your friends to do the same. We'll be back another time. Same bat time, same bat channel. Y'all have fun. Y'all take care. Talk to you again real soon.